Damin Murdock from Leo Lawyers, and while this looks and sounds like me, you're actually watching my AI avatar speaking from a script that I've personally approved. Now, let's get to the important part. If you're running a profitable business, you've probably heard the term discretionary trust thrown around. Maybe your accountant has mentioned it, or you've seen it in discussions about tax planning and asset protection. But what does it actually mean, and how can it help you protect what you've built and legally reduce your tax? In this video, I'm going to walk you through exactly how a discretionary trust works and how you can use it to distribute income in a way that benefits you and your family. By the end, you will have a clear understanding of whether a discretionary trust could be the right structure for you and the key points you need to get right before setting one up. Discretionary trust, which is also called a family trust, is a separate legal entity that's often used to hold assets such as shares in a business or property. There are four parties involved in a discretionary trust: the settlor, the appointor, the trustee, and the beneficiaries. The settlor is the person who brings the trust into existence. In medieval times, that might have been a king, but today it's often your accountant or your lawyer. Importantly, the settlor must be an independent person who has no beneficial interest in the trust assets. The appointer is the person who ultimately controls the trust and its assets. You can think of them as the sole director of a company. The appointer has the power to appoint and remove the trustee. The trustee is a bit like the CEO of a company. They have a fiduciary duty to act in the best interests of all the beneficiaries. The trustee can be either a person or a company, but the trust itself can't do anything without the trustee. The trustee is the one who signs contracts, opens bank accounts, manages the trust's assets, and importantly, decides which beneficiaries, if any, will receive a distribution of income or assets. For example, if the trustee holds shares in your company and your company issues dividends, those dividends go to the trustee, who then decides which beneficiaries will receive them. Beneficiaries are the people or companies named or described in the trust deed. They have no right to receive anything until the trustee decides to distribute. In other words, they're waiting for the trustee to make that call. When someone starts a company, they'll often have the shares held by a trust rather than holding them personally. This can provide both tax benefits and asset protection. From an asset protection point of view, if the shares in your company are owned by your trust rather than by you personally, and you go bankrupt, your personal assets might be taken by the trustee in bankruptcy, but the trust's assets are separate and may be protected. From a tax point of view, the advantage comes from how the income is distributed. Let's say your company makes $100,000 profit. It pays company tax of 25%, which is $25,000, leaving $75,000. That $75,000 can be paid as franked dividends, meaning the 25% tax has already been paid. If your trust holds the shares, those dividends go to the trust, and the trustee can decide how to distribute them among the beneficiaries. For example, the trustee might decide to give $20,000 to your non-working spouse, $40,000 to you, and $15,000 to your siblings. Each person pays tax at their own marginal rate, less the tax that's already been paid. Your non-working spouse might pay little or no tax because income under $18,200 is tax-free. This is what we call income distribution, and it can result in significant tax savings for the family group. trustee can be an individual or a company. If it's an individual, you save on the ASIC annual renewal fees, but it's not always the best option for succession planning. This is because if you die, then there will be a requirement for you as trustee of the trust to arrange for the shares in your new company to be assigned to a new trustee. However, if you have a company as the trustee, which we refer to as the corporate trustee, then in this case, the shareholding does not need to change, and instead, you simply arrange for the directorship and shareholding of the corporate trustee to vary. It's also important to understand that there are situations where a trust's assets can be opened up by the courts. For example, if the trust is used to commit fraud, if it's a sham, or under certain family court orders. To minimize that risk, it's common to set up a trust where the appointor, trustee, and beneficiaries are different people or companies. That might mean your parents are the appointers, you're the trustee, and the named beneficiaries are you, your spouse, your children, and other family members. In terms of costs, a standard trust deed is usually around $1,000 plus GST. If you have a corporate trustee, you'll also need to pay to incorporate that company, which is about $900 plus GST, including the ASIC incorporation fee. Depending on your state, there may also be stamp duty, often around $750, plus a small fee for an agent to process it. And remember, if you have a corporate trustee, ASIC charges an annual renewal fee, which is around $330 a year, although it can vary. A discretionary trust isn't just a legal structure, it can be a key part of a long-term tax and asset protection strategy. But every situation is different, so before you set one up, speak to a lawyer and an accountant to make sure it's right for you. If you'd like advice on the best structure for your business or investment, you'll find our contact details in the description box or visit leolawyers.com.au and let us help you build a smarter financial future.